So if we're going to be looking at the intention of the parties, and that is now the framework through which we are going to view employment termination clauses, there is an argument that even the most carefully drafted termination clause is unenforceable.
Welcome to Water Cooler Justice. I'm Chris Robertson. I've been practicing employment law for over 20 years, helping clients resolve disputes and navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant and soon-to-be paralegal.
Yeah, congratulations, Sarah. That's awesome.
Thank you. Thank you.
I'd like to extend a warm welcome to all of our listeners, both new and old. Thank you for tuning in and supporting Water Cooler Justice. We know how many of you there are. It helps us in our publishing if you take a moment to follow us on Spotify or Instagram. We do really appreciate the support. This is episode 15, and I am excited to introduce a brand new panelist today, John Pinkus, who will be joined by fan favorite and friend of the show, the legendary Mr. Barry Fisher. John Pinkus is a partner at Samfiru Tamarkin and a premier employment lawyer who represents both employees and employers across Ontario and British Columbia. He has extensive experience handling wrongful dismissals, severance negotiations, workplace discrimination and harassment issues, human rights complaints, employment contract negotiations, and he's often celebrated for his relentless dedication and exceptional client service. Side note, I have read and relied upon many of John's decisions. With a proven track record before tribunals and courts, including the Ontario Court of Appeal, John has earned a reputation for his tenacious approach and personalized legal strategies that consistently yield successful outcomes. Outside the courtroom, he's a former ski instructor, an accomplished guitarist, and a classically trained pianist. Barry is a leading mediator and arbitrator in employment and labor relations, bringing more than 30 years of experience as an employment lawyer and legal author to his work. Known for his evaluative approach to mediation, Barry combines deep legal expertise with a strong understanding of the psychological dynamics that drive workplace disputes, helping him achieve settlement in more than 85% of the cases he mediates. He is also the author of the Wrongful Dismissal Database, Canada's first and leading online resource for reasonable notice periods, which is relied upon by employment lawyers, HR professionals, and judges. Barry's unique blend of legal insight and practical problem solving has made him a trusted voice in the field of workplace dispute resolution. John and Barry, thank you for joining us today. I'm just going to start. We're going to launch right in. What have the last 2 weeks been like for you guys? I know I've seen a lot of posts on LinkedIn. I know that I've had to go back and look at a lot of cases that I have ongoing, both on the management when I'm on for management and when I'm on for the plaintiff. And it has been an exciting couple of days. I don't think I've read this many cases in a 3 or 4 day period, except, in preparing for trial. So lots going on. You guys?
Well, I think that for cases in which the at any time or any reason phrases were the only arguments available to the plaintiffs, I think a lot of those have resolved, although not all of them, because I suspect I suspect that the Supreme Court of Canada will take interest in this very, very odd decision. And then on the flip side, a reevaluation of any cases involving RSUs, where there is now very little reason for plaintiffs to compromise on those entitlements. And I think that also leaves an open question as to whether those agreements taint the employment agreements, even when they have otherwise enforceable language. And I think we're going to see a lot of cases where the exclusion of RSUs is going to wipe away otherwise enforceable employment agreement language. So, yeah, it's going to be an interesting time.
So, Barry, your thoughts?
Well, the last 2 weeks have been very exciting for me, but most importantly, I had my first grandson yesterday.
Oh, that's fantastic.
So that's way more important than all these stupid cases. So I just wanted to get that out of the way. Life does go on, notwithstanding the Court of Appeal doing what they did. Unlike you, Chris, I read a lot of cases. I realize that this is the first time you've had to read 2 cases in 2 days.
I don't know how I feel, but I like to feel that my research is very focused, Barry.
Notice he did not say, I haven't read this many cases since law school. I just make a note of that. Anyways,
Yeah, every once in a while I dust off the books. Come on.
Yeah, it's interesting that obviously the two panels didn't talk to each other, and I guess they're not really allowed. I found that the most interesting difference was this debate about the savings clause versus the exception clause. The anytime argument, whatever. I mean, yes, it's highly technical and all that, and whatever. But as I've always said, those are stupid words. I don't know why they were ever in there. Lawyers just feel sometimes they get paid to add extra words. So whether they're there or not, and that's an easy fix. You just sort of plug into your computer. Anytime it says anytime, delete it. And a lot of employers, I think, have caught on to that one. The more dramatic one is I think, a fundamental difference between this savings clause versus exception clause.
Right.
In Baker, which was upheld, they had a just cause clause with a whole list of a whole bunch of stuff, which is usually junked right away. But it said with the exception of the ESA. But what's interesting is, and the court made a big deal about how they intended it to cover this and everything. But I looked at Baker today. There's two clauses. One that says if you're fired for just cause, you get nothing unless it's ESA. So one could say that willful misconduct, you get nothing. But the without just cause clause is just ESA only too. So,
Exactly.
so the list of 6 or 7 items is actually irrelevant. The only way to read that is to ignore those 7 items.
To give those words no meaning.
We're not supposed to do that in interpreting a contract. To just ignore it. Now,
I agree.
That was not raised in the Court of Appeal. Maybe if it ever got to the Supremes.
So Barry, let's give the listeners a chance to catch up with us, right? Like we've been living a hurricane or a whirlwind for a couple of days. Sarah, why don't you read us in so that we know sort of what's going on and our listeners can catch up a little bit, and then we'll come back to some of the technical arguments and some of the unusual arguments in this particular appeal.
Yeah, sounds good. So let's begin with Baker v. Van Dolder and Lee v. Wayfair. So these appeals were held together on March 25th, and the decision was released on August 6th. The core issue in both of these cases was whether termination language containing the phrases "at any time" or "for any reason" violates the ESA. Baker argued that the phrase "at any time" purported to give his employer a right to terminate him genuinely at any time, including, for example, during a statutorily protected leave, which the ESA expressly prohibits. Now, Lee made a similar argument, but his contract went further and included the phrase "at any time" and "for any reason." Lee argued that this language was even more problematic because it purported to give his employer the right to fire him for any reason, including reasons prohibited by statute. The motion judge for Baker found both the with cause and without cause provisions were unenforceable due to their inconsistency with the ESA and ordered a 1-hour hearing to determine damages. Van Dolder appealed the decision on several grounds. They argued that the motion judge erred in interpreting the termination provision by failing to read the agreement as a whole, disregarding relevant precedent, and failing to properly consider the employer's duty of good faith. And further to this, Van Dolder argued that the Ontario Court of Appeal's refusal to leave to appeal on Waxdale v. Swagan should be overturned. The trial decision for Mr. Lee was a dismissal of his claim. The motion judge upheld that the employment contract was valid and enforceable. Lee argued that the judge placed too much importance on the general savings language and that he failed to interpret the contract in a way that protects vulnerable employees. So my question to the panel, the court seemed to place a particular emphasis on 2 themes. 1, the intentions of the parties, and 2, the importance of interpreting a contract as a whole while considering the surrounding circumstances. So why did this decision spark so much debate amongst the employment bar? And do these decisions signal a broader shift in how the Ontario Court of Appeal is approaching contractual interpretation?
Well, I don't know if it's so much of a debate as it is a victory lap, right? Like I see a lot of management counsel posting a lot of briefs and a lot of posts on LinkedIn and social media about this case. And so I think I can understand why management council would want this case to represent a broader shift. But is that what we really see here, Barry, John?
Well, one question that I don't think any management council have considered, but their clients are going to have to consider this, is if it is a broader shift, what exactly is that broader shift entail? Because if it entails looking at the intentions of the parties, plural, not the intention of the employer, but the intention of the parties, plural, then we could be on the road to no employment clauses being enforceable because, or very few of them. Because if we're going to go down that road, one has to be very careful in remembering that, this idea that employees understand what they're agreeing to when they sign off on these clauses. And I have the benefit of having a very large sample size of having spoken with thousands and thousands of these people. It's a fantasy. No one has any idea what these things mean because no employers spell it out to them. They don't spell out what the ESA means, and they certainly don't spell out what the common law means. So if we're going to be looking at the intention of the parties, and that is now the framework through which we are going to view employment termination clauses, there is an argument that even the most carefully drafted termination clause is unenforceable. Frankly, there's an argument now that I wouldn't have said there was an argument before, that a clause drafted with the exact language of the Birch clause is unenforceable, because did the employee in Birch intend to limit their entitlements to a week per year? The employee had no idea. And this, ironically, was the point of the Moreau article, Stephen Moreau's article, which is cited towards the beginning of the decision. Basically, what the Court of Appeal appears to have done is they cited the preamble of Mr. Moreau's decision, but doesn't actually grapple at all with the thesis of that decision. And the thesis of that decision, of the article, the thesis of that article is effectively, if we're going to enforce termination of employment clauses against employees, given how vulnerable they are, we should at a bare minimum have to prove that they understood what they were signing. And if employers are obligated to do that, watch out, because there's going to be virtually no enforceable termination clauses going forward. So I think this victory lap is very ill-conceived, and I think a lot of management lawyers don't understand the actual potential implications of this, which could easily blow the other way.
Just a quick follow-up, John. You don't think employers could cure that by, attaching a pamphlet or something about the ESA with their offers?
They could. They could do that. But how many employers have done that?
Nobody does that. Nobody. Yeah, like when I got my first job, I only cared about how much I was getting paid. I did not read the fine print, and I certainly wasn't worried about termination because it's contingent, right? It may never happen.
Yeah, so I want to make sure I'm not misinterpreted on this point, because I'm not saying it's going to be impossible to prepare a termination clause. In fact, before this decision, I would have said it is incredibly easy to draft an enforceable termination clause.
Agreed.
The Birch decision showed exactly how to do it, and there are many versions similar to that that would have been perfectly enforceable. But still, I see people use the exact language from Birch, and then at the end they put something, by the way, we're not going to include your benefits. By the way, we're not going to extend your disability benefits. By the way, we're going to terminate you for cause and not pay you anything. And then it's, of course, is completely unenforceable when they do that. So it was very easy to do that. And I think it's going to be harder in the long run if we go down this route and take it to its actual logical conclusion. So I'm not saying it's impossible, but I'm saying that there is a world where it has just become much harder to enforce termination clauses once the case law develops and the courts are forced to deal with this idea of not just what did the employer intend, which is which you of course you can't get that just from the employment agreement.
Barry?
Well, the employer is presumably a corporation, but I don't think corporations have ideas. Only people do. So presumably the person who knew what the corporation meant was the person who signed the letter, the employment letter. So I have it on good measure from a dear close relative of mine who happens to be a plaintiff's lawyer that he intends to ask all sorts of questions on discovery of the sales manager who signed the agreement about what his understanding of the ESA was and what his understanding of the common law is. So, on the other hand, I'm also informed by this same source that he's sure that his plaintiff clients are going to say, "Oh, I fully intended to retain my common law rights." So, you're right, it's going to be this insane idea that we're going to have to do discoveries now to find out what the intention of the parties was. And that's just not the way we interpret contracts. The intention is expressed in the agreement. Many, many years ago, because I've been around longer than any of you,
it's not a competition.
I actually gave, well, I'm not proud of it anymore, trust me. I would take 20 years off. I would be 20 years
younger. Give 20 years back, would you?
Yeah, all right. Sure. Not the money, but the 20 years I give back.
All right.
I gave a speech to a group of judges in New Brunswick. It was a conference, whatever. And back in those days, this is the early 80s, there was a fundamental dispute about what the implied term of reasonable notice meant. And early cases said, well, we have to look at the intention of the parties, which is completely ridiculous. The employer, and of course, the employer intended to pay you as little as possible. That was the intention. They almost never looked at the party's intention. And I delivered a paper saying that was ridiculous. You can't look into someone's brain. And then later on, I can't remember in what decision it was, the Supreme Court of Canada, I think it may have been MacDinger, said, it's not a matter of discovering the intention of the parties. The implied term of reasonable notice is a function of law, and we get to decide what it is. We're not trying to figure out what the parties, they used to phrase it, had the parties thought about it, what would they have agreed upon? And
right.
It was insanity. And I think to some degree, we're back there again. In the Baker decision, they go through the citation, they quote the fact that commercial transactions are to be interpreted differently than employment things. And then when they refer to cases about how to interpret, they use SAFA, which was a commercial case. And they don't apply their own principle of interpretation. So I agree with John. This is going to complicate stuff, which is the mediator, I guess I like. And it's going to bring on useless discoveries of what was the intention of the parties.
Well, but here's the other thing that
okay, go ahead, John.
If I can just jump in, that I think we probably should have said at the beginning, because everyone needs to remember that Baker was a 3-judge panel that does not purport to change any prior decision.
Right.
Which means it doesn't purport to change Wood, which explicitly says we do not look at the intention of the parties, which they got from the Supreme Court of Canada in MacDinger, which explicitly states we do not look at the intention of the parties in pretty straight contradiction to Baker. So it doesn't purport to overturn Wood or say that Wood is bad law, because it can't, of course, but it contradicts Wood. And it doesn't purport to overturn Rossman, which says that you can't just say, the magic words Employment Standards Act. And I love how employment counsel are talking about, there's this fallacy that, you say the magic words and the clause is illegal. Okay, well, now we're on a fantasy that you say the magic words and the clause is illegal. I mean, this is the same thing, right? Oh, we say Employment Standards Act, so it doesn't matter if we say that we can pay you nothing on termination. We said the magic words, ESA. So Rossman says that's nonsense, and that's still good law. So it's not like any employer is going to be able to say, well, no, you can't consider Rossman, that's out of date. It is officially not out of date. And that's before we even get to Wigdor, which came out the next day, which reaffirms all of those principles. So this notion that Baker has changed things, not only did it not change things, it could not have possibly changed things because it was a 3-judge panel. The only thing that it can change, and the only thing in my view that it did change, is our clauses in which any time and any reason are mentioned. And even in that case, it didn't change all of those clauses, because some of that language can still be illegal if you have language such as sole discretion, any reason whatsoever, and you don't have the Employment Standards Act baked into that sentence. So even those clauses are still a live issue, but it certainly didn't change any of the other cases.
Right. And just to simplify for the listeners who are not lawyers,
fair enough.
In Baker and Lee, what we had cases going in opposite directions on largely the same issue. So in one instance, the employee was successful, and the other, the employee was not. And what John's saying is that just because the Court of Appeal on this particular set of appeals has found in this direction, there are other appeal court decisions that go in an opposite direction. And so one way of thinking about Baker and Lee is we're no further ahead. Right? We still have competing decisions, or we have competing lines of reasoning. But I think at any time is problematic in an employment agreement. And I don't know, as Barry says, that it adds a whole lot.
What will be, I have it on I've heard through the rumor world, whatever, and talking to various people, I have a funny feeling everyone's going to seek leave to appeal. Now, what would be interesting is if they, at first blush, they don't look similar, why would they be heard together? But I'm wondering, and I wish, that council would get together, and the issue to put before the Supreme Court of Canada is this, not the anytime issue, not the RSU issue, but the exemption issue, the savings versus exception. Yeah. I have strained myself to understand the difference. What has been explained to me is as follows. If you say something illegal, but then contain the same sentence, say, except as required, that seems to be okay. But if you say something illegal and then have another sentence, God forbid, in a different paragraph, which then paraphrases it, which then says, but not if you always get the ESA, that somehow that's a savings clause and that's not legal. To me, those are distinctions without a difference. Either you can state an illegality and then get out of it by saying except as required, or the better drafting is just don't ever state the illegality. I don't frankly understand. The only people that know how to draft a perfect termination clause, you know who they are? Plaintiff lawyers. Ask any decent plaintiff lawyer to draft a perfect clause. I blog a lot about this stuff, and I had an HR lady send me an email. Thank you very much, Mr. Fisher, for your commentary. Would you please provide me with the perfect clause? And I wrote back, no, I'm not giving away, but it's true. Plaintiff lawyers only talk to each other about this, but it's really easy to draft it. So I frankly do not understand why courts bend over backwards to necessarily help employers who are just lousy drafters.
Can I just speak into the my views on leave for these two cases?
Mm-hmm. Yeah, please.
So in the Wigdor case, this is a very, very Ontario-centric issue, right? This is the interpretation of specific sections in the Ontario Employment Standards Act.
I think every act, I haven't looked at them, but I can imagine most Employment Standards Act contain a cannot change terms during the notice period clause.
They vary wildly.
The only thing unique about Ontario, for one of the unique, is the willful misconduct.
In fact, a lot of provinces like BC, for instance, there's no obligation to extend benefits. No, this is a very Ontario-centric requirement. So I don't see a credible basis for Facebook to seek leave in that case. But in the Lee and Baker cases, I mean, when you read the decision, it's basically a challenge to Machtinger. Machtinger says, which is a Supreme Court of Canada decision, Machtinger says, we do not look at the intention of the parties. Let's be absolutely clear. We do not do that. And here's the reason we don't do that. And that's something that courts have followed for 30 years. And Baker does not acknowledge that principle at all. And it is the very foundation of Mattinger. So it's difficult to see how the Supreme Court of Canada would not be interested in that, because that obviously has national implications. It's a direct challenge to their own jurisprudence on a 3-judge panel, no less, from the Court of Appeal. So I think we're much more like, I mean, look, leave applications are always rare, of course, but I think we're much more likely to see interest, to the extent there is interest, on the Baker and Lee appeals than the Wigdor. And to the extent the Supreme Court of Canada doesn't take up that issue, the Court of Appeal is going to have to in future decisions. They're going to have to figure out which is right, the 12 decisions from the last 30 years on this issue, or this one decision that issues the principle that we do not look at the intention of the parties. So it will be interesting times ahead, either way.
What's also
Right, but-
interesting in Baker was I watched the whole thing, and I don't recall any oral argument about this savings versus intention clause. It was, as I recall, it was all about the anytime argument. So I was quite surprised, actually, to go, oh my God, I didn't even know that was an issue. Presumably it was raised in the factums, but I don't recall it being raised orally, frankly.
So is there any magic in the exception language, as I understand it, the language which was used was ESA entitlements, right? Is there some magic to the word entitlement? Is that somehow all encompassing?
You mean in Baker?
I believe in Baker, the exception language was you'll receive all of your entitlements or something along those lines.
I got it right here. Well,
Yeah.
Your termination without cause, we may terminate your employment anytime without just cause upon providing with only the minimum notice or payment in lieu of notice, and if applicable, severance pay required by the ESA. If any additional payments or entitlements, including but not limited to making contributions to maintain your benefits, are prescribed, you'll get those too. So it seems to cover everything. I don't recall that being an issue that they left out one of the
Right.
list.
Well, it doesn't sound like it was. It doesn't sound like in your recollection it was argued with great vigor. But one of the things that I'm interested in is, should employers be snapping that accepting language or that exception language onto the back of all of their termination provisions?
Sure. Once you've got the Supreme Court of Canada, once you've got the Court of Appeal saying this clause is okay, sure, cut and paste.
Well, it's not that they said the clause was okay. They said it was possible to interpret it as breaching the ESA. And then they said, but there's this accepting language, which we use to interpret which we use to as evidence of the intention of the employer, right? Is that have I phrased that correctly?
Yes, which of course is another repudiation of the binding jurisprudence of the Supreme Court of Canada, which specifically says that if there are two ways to read a clause, you read it in the way that benefits the employee. And it's almost as if the Court of Appeal and Baker are suggesting that, well, it benefits the employee to have certainty that they're getting the least amount of money possible. I mean, that's how I interpret the decision. And that to me is very difficult to understand how that is the greater benefit to the employee. Because remember, it bears repeating that this decision does not purport to change any of the law that came before it.
Fair enough. And what about the idea or the buttressing of the decision by referring to the consequences to an employer that fails to comply with the ESA, the fines, etc. I had some real problems with that when Wigdor came out the next day, and poor Mr. Wigdor, he didn't get his ESA entitlements, and the Court of Appeal shrugged its shoulders and sort of said, well, it's a nothing burger. I got to tell you, I got to tell you, if I was entitled to 10 months compensation on termination under the ESA and I didn't get it, that would have a meaningful impact on me. And I would suspect most employees.
He got his $4.7 million. They weren't going to give him any more than that.
Fair enough, but I don't think the decision's helpful on the next day, right?
Well, no, but you've raised another issue too. In response to this Baker interpretation and throwing out half the arguments that plaintiff lawyers have relied upon, plaintiffs' lawyers are getting creative, and I've heard from a couple sources, not the same source I had before, was that one of the things they're going to argue now is repudiation.
Correct.
You didn't follow the ESA. You paid me my severance pay 8 days late. 8 days, not 7 days. You've repudiated the contract. I couldn't care less whether it's enforceable. We're back to the common law. So
I
I think
agree.
plaintiffs' lawyers are going to go through with a fine-tooth comb every tiny little violation. Did you pay vacation pay on the termination pay? Did you pay it in 7 days? Did you continue my pay in lieu of notice on instead of a lump sum? There's a lot of crazy technicalities.
Did you exclude incentive compensation from the regular wage compensation calculation?
Yeah, did you do the 12-week calculation and all that?
Right.
So I think they're going to turn around and say repudiation and
Though
that goes.
I have to say, although I agree with that, I think the employee intention is going to be much more interesting than the employer intention, because employee intention has to be part of this analysis. It's the only way it makes any sense, and that's where it's actually difficult to see 99% of employers winning. If we look at employee intention, they really should be losing every time, and that's the Baker framework.
But what's going to happen in reality is there was no common intention. So what happens then?
Well, what happens then is that the contract disappears, and we're back to common law.
Which, as a matter of law, common law is inferred, right? That's
an implied term. You don't need a meeting of the minds for common law.
In Mactinger, isn't there? There's an addendum, or there's a lone judge. I think it's McLaughlin, who writes about how she gets to common law as an entitlement in the absence of a contract limiting. And it's pretty compelling, right? If you're going to read Mactinger, you should read that last little section, because it doesn't really apply. It doesn't really apply unless the contract disappears, right? And I think that's telling. I mean, in terms of what John's suggesting, that there was no meeting of the minds. So interesting.
If you interviewed the person who signed the contract on behalf of the employer and the plaintiff, and they both agreed that they didn't really understand any of the termination clause, so there was no meeting of the minds, what's the consequence of that legally? That the contract's null and void?
I think so. I mean, if there's a meeting of the minds is a foundational requirement of contract. I mean, if there's no meeting of the minds, then it's as if the contract was not signed. And if the contract was not signed, what are we left with? We're left with the presumption of reasonable notice.
Yeah, I agree. I don't think that's wrong. But what's fascinating to me is I got hired 20 years ago, and my hiring manager left the company 3 years later. What witness is management going to call?
This happened in a case David Harris had many years ago about that ridiculous argument of whether LTD is deductible or not deductible. And the issue, anyways, they looked at the intention of the parties, and Harris knew that the defense representative was dead. So the plaintiff said, we had this discussion and whatever, and they couldn't contradict it. Again, it was ridiculous. You're right. What are the odds of the employer ever being able to dig up the person who either drafted it or signed it? Is it the intention of the person who signed it? Is it the intention of the person who drafted it? I don't know. What if it was drafted by a committee?
And this is why
What if it was drafted by defense counsel? Do you get to examine him or her? I mean, it's crazy.
Well, so Barry, tell me a little bit more about that provision in Baker. You early on, you were talking about how there was language in there that clearly was not willful misconduct, I believe, for the purposes of the ESA. Right? So how does the court square that up?
Well, they don't address the issue of because the without cause clause says you only get the minimums. And then it must be that the the 6 items listed are just irrelevant. We ignore them. They don't mean anything.
Right. And of course, that's a principle of contractual interpretation.
Correct, that we don't ignore.
You do not ignore words, which is the same problem with any time and any reason, because you have to ignore words in order to argue
now that
meaning.
particular issue was not raised, so I don't know if it could be raised at another level, but so we're having an intellectual discussion here. Yeah, because usually as soon as in the olden days, like last Wednesday, unless they quoted the words exactly, you had an avenue to argue. And these were the easiest ones. They got down poor performance.
Right.
But wait a minute. Let's just. I'm gonna, and maybe this seems pedantic, but you did not have to quote those words exactly. I mean, Birch did not quote those words exactly. You just had to have a clause that did not expressly have illegal language. That's all you did need to have, right? And now the court seems to be saying, well, you can have illegal language sometimes. Sometimes you can, sometimes you can't.
You have to say except any minimum compensation. You have to use the magic words of accept.
Well, I'm going to put on my management hat just for a moment. I don't think it's quite that simple. I think what they're saying is that if the offending language or the language which breaches the ESA genuinely breaches the ESA, whatever genuinely may mean, then there's no analysis of intention required. It's only if the language possibly breaches or fails to rise to some clear standard of breach, and then you engage the intention of the parties. And so for me, one of the things that I've struggled with is what's the difference between possibly breaching the ESA and genuinely breaching the ESA? Is it ambiguity versus an express and obvious contracting out?
Well, I think that the difference is an affirmative breach, right? We will not pay you anything other than such and such. We will only pay you notice, and that will be your full entitlement. You will not get severance. We will I would have thought that it would be, we will terminate your employment for just cause and not pay you anything. We will terminate your employment for breach of this confidentiality clause and not pay you anything. That is an affirmative statement that is in direct breach of the Employment Standards Act. Whereas on the other hand, if you say, we're going to pay you your notice or your wages or your base salary and
how about salary? Yeah.
And your entitlements, but in accordance with the ESA, then Baker would say, the ESA is baked into it basically, and so we're going to enforce that language. So I think the way the courts are going to deal with it, I mean, until we get to this intention issue, which is a whole other can of worms, but leaving that intention issue aside, if a plaintiff did not bring evidence of their own client's intention, which would be easy to do, but if they don't do that, then all the court will say is the Employment Standards Act and their entitlements, is that baked into the same clause that the employee is challenging? And if it is, then the court would probably enforce it.
So in a pleadings matter, say you plead, you don't talk about the contract, the employer files a defense citing the contract. Would it be good practice for plaintiffs to file a reply saying the plaintiff never intended to give up his common law rights? Because presumably you have to put that issue at stake.
Yeah, I think so. And in fact, you may not even, I think a lot of plaintiffs will just preemptively put it in their statement of claim. Why even wait for a reply? I mean, if you know it's going to be an issue, my advice to my plaintiff colleagues would be put that at issue in every case now, because if we're talking about intention, what's good for the goose is good for the gander, right? I mean, that's how it's got to be going forward.
Right.
I think that this is actually a good place for us to maybe have Sarah read the outcome. And I think we should revisit Wigdor in another episode. Perhaps John, you'll join us again. We can call it "What a Difference a Day Makes" Part 2, right? Because the cases came out 2 days apart. I also think what a difference the amount of judgment makes, but that's a conversation for another day.
So the court found that both termination provisions in Baker were compliant with the ESA and therefore enforceable. The summary judgment order was set aside and Baker's action was dismissed. He was ordered to pay Van Dolder $2,500 in costs, inclusive of disbursements and taxes. The court dismissed Lee's appeal and ordered him to pay $10,000 in costs to Wayfair.
That concludes today's discussion. I want to thank our panel for a great conversation, Sarah for keeping us on track, and our listeners for tuning in. If you like this episode, please subscribe or leave a review if you have a case you'd like us to discuss, or if you'd like to share your own story of workplace drama, and we love workplace drama around here. Email us at watercoolerjustice, all one word, @gmail.com. Until next time,